না না প্যানেল ওয়েবসাইটে এটা কি দিলি? এটা কি আমাদের পয়েন্ট?
I'm appearing for the School Service Commission. I'm being led by Mr. Kishore Datta.
Well, I'm appearing for the appellant. The first order. I appear for the added respondents. Server ki added hoye gache? Server added.
Only one thing before the appellants start any argument. The matters are appearing at our instance.
এটা এফিডেভিটের রিপ্লাই তার রিপ্লাই এটা সেই পয়েন্ট ওয়াইজ পয়েন্ট গুলো নিয়ে
ওসিটা দেখে নেব। ওসি কেন আছে? ওসি মামলা আছে। সদা যে কি করছে সবাই
ফাইল এফিডেভিট দ্যাট ওয়াজ নট গিভেন এসএসসি
কোন ম্যাটারটা? আইটেম 16 সার্ভিস আছে আমাদের উপরে। দেখো তো।
আচ্ছা জজ সাহেবের অর্ডারটা এই ফার্স্ট যখন অর্ডার
তুমি বলেছিলেন একটা ম্যাটার সার্ভিস হয় পাওয়া যাচ্ছে কতটা চেঞ্জ করে এই মধ্যে উপর সার্ভিস হচ্ছে
জি এই অর্ডারটা এটার ফার্স্টে অ্যাটাচ করা আছে সেকেন্ড এফিডেভিটটা আমরা দিচ্ছি
items 15 and 16 were not served upon the commission. That is why affidavits could not be given to the concerned advocates, but all the matters we have given them, and in the first matter that is Rajiv Brahma matter, the appellants have also given a reply.
So this is ready for hearing.
Now, these are those upper primary matters which we were proceeding subject to the directions of the Honorable Court. So from time to time your lordships had given us certain liberties on the basis of which we have completed the entire exercise. Now the panel and wait list and a list of rejected candidates who were rejected due to various reasons, they are all ready. Those I have brought to court. So all that is now left to be done is to start the counselling, for which these lists are required to be accepted and published in the website of the commission so that we can start the counselling. Your lordships will recall by the judgment dated 20th July 2021, your lordships had set out the guidelines how to proceed. 7 stages were given to if your lordships would kindly see the judgment, the order dated 20th July 2021, what your lordships had initially directed. Internal page 10 of the order. Having heard the parties and anxiously considering the materials placed at this stage, this court by way of an interim order directs as follows. First, the commission shall continue to hold the interviews of all the candidates whose names appear for the personality test. That was done, it has been concluded. After which the second stage, the commission shall conclude the interview, grant marks in the personality test and prepare a panel of the successful interviewees. That has also been done. That is what we have brought today before the court. So the panel, which includes the waiting list also, the panel and the waiting list, that is ready along with a list of the candidates with the reasons why they had to be rejected, why they fell beyond the zone of consideration. And the third is the commission shall not grant appointments from the panel of successful interviewees without the leave of the Honorable Court. So commission actually does not issue appointment letters, it issues the recommendation letters. The board issues the appointment letters. So going by this order, we have now reached the second stage and we are ready to upload the panel and wait list and start calling the candidates for the recommendations. There is actually no bar by this order preventing us from proceeding, but still we have come up before your lordships just to show that we have completed the exercise to this level and at least try to satisfy your lordships that everything has been done properly and correctly so that we can now start the counselling. The 12,000 candidates, more than 12,000 candidates will be employed if this exercise can be done. Schools are suffering since 2016 without teachers.
Dr. Patra, please let us go through our order and then check up that.
Study. के बाद पर तो चार्ट আছে জানা আছে আগেরটা এই যে যেটা ওই একটা মোটা আছে তো আবার সেটা ফুল করা আছে তো যেন দেখতে নিচে বাদ হাফ হাফ which is not theoretically we will say ask really what is it that's
Yes, now please place the directions from fourth.
order গুলো আছে ইনক্লুড করে
করছিলাম কাগজ থেকে অর্ডার
Yes, the internal page 11.
11 of
Yes. So I just placed up to the third point where the appointments are to be withheld, but the panels are to be prepared. Panel waitlist is to be prepared. Then the full commission shall prepare a clear database of the successful candidates in the personality test, which shall include, among others, the actual statutory marks of the individual candidates in terms of their certificates, qualifications specified by Rule 12 of the 2016 rules, plus the weightage given against each such actual statutory marks, plus the marks obtained in the personality test, and on the basis of such procedure, their individual relative position in the combined merit list. So combined merit list would mean the panel and the wait list together is referred to as a combined merit list. So that is all done. This is the hard copy of the database. Because whatever data is in the database, it has culminated into these panels and wait lists and everything. So everything is now ready.
You are Mr. Dr. Patro. These gentlemen feel they have been left out of the weightage from the very beginning. So you were directed to even produce their database as far as we can make out from that. You cannot only give your successful database and the waiting list panel. Kindly see what is recorded as 6th and 7th.
that's a
My lord, all the candidates, their details is in our database. That is undoubtedly there. Now producing the entire record, that would be
You have to do something like whatever has been directed by item numbers 4th, 5th, 6th and 7th. Up to 3rd you have done. 4,
Yes.
5, 6 and 7 also you have to do.
and it has not
That is all that we want.
May I place and then I will try to respond. The Commission shall simultaneously proceed with the redressal mechanism set in place by the Honorable Single Bench.
Which means, in other words, sorry to interrupt you, you
Yes.
have started the process of interview. You have given weightage to candidates and then you have also called them for interview. You were asked to do that.
Yes.
At the same time, side by side, you were asked to also calculate the weightage in the database for those candidates who are appellants before this court. And give them an inspection of both the data, your merit list and their own weightage. And with their original marks, the weightage you calculated. All this exercise you were supposed to do before your interview can be allowed to go through. Kindly see 4th, 5th, 6th and 7th. Don't only speak of your interview, your merit list, your wait list. Speaks of even their statistics, their weightage of marks, their relative position in the compared to your merit list. And
May I-
what is your grievance redressal mechanism found after that?
Yes, our grievance mechanism, it entertained, it received 18,000 applications, and out of which 15,000 and odd were present, the remaining were absent. Each one was given a separate and individual hearing, and each grievance was redressed by passing a reasoned order. Out of which 1,585 and a few others later on, they succeeded in the redressal mechanism. We approached the court with that result on the previous occasion, and your lordships on 30th of September 2022 passed an order allowing us to include those 1,585 candidates in the interview, and we also held their interviews. So the grievance mechanism was done. Possibly the only thing which I do not have in my hand right now, though it is definitely in our computer database in the Commission's office, that is a chart showing the exclusive results of the appellants before the court. Only that is possibly what I do not have in my hand right now.
And what does it show? What does the exclusive result show? That they are not they are not qualified.
No, that would not be correct. Some of the appellants are in the panel, some of them are in the waiting list, and most of them are definitely, they have been rejected. So the total candidates, not just the appellants, everyone had to be checked. So appellants, the total appellants, I don't know, I have not calculated, maybe 100 or 150 appellants might be before the court, but the entire approximately 1.5 lakh candidates, their credentials had to be checked before we could prepare an interview list. So on the basis of their performance, on the basis of the TET weightage and the academic scores, the interviews have been held. So no injustice has been done, but what is not in my hand today is possibly a special chart which I could have prepared from the database showing the exact position of the candidates. What we had actually thought is that if the court grants the leave to us to upload these, it is not that there is an embargo on us, because the court has allowed us to come up to this stage. So if we upload the panel and the wait list along with the list of rejected candidates who we have, then the candidates, the appellants before the court can automatically see what is there and they can compare for themselves.
Yes.
In addition to that, since there is a direction of the court, we will also upload a special chart showing their position vis-a-vis the candidates. That part also we can do. But the grievance, it is not correct to say that all these stages have not been done. The grievance hearing was a huge exercise, giving personal hearing to 15,000 who were present. 18,000 had applied. It was not.
We got you. So now, Mr. Shangal, what is your further complaint?
Now, further complaint, I tell you, lordships. If your lordships take up the 2 affidavits, they are filed, very short affidavits. Your lordships will get it out of that. Now, the very serious grievance now comes up for your lordships that they do not have the OMR seat of TET. There were 2 TET candidates appeared in this process, 2011 and 2015. But according to them, both the 2 affidavits are not available to them, OMR seats. Now, it comes up from the affidavit, the total merit commission first disclosed 12,589 merit listed candidate. They have said. Now, I will take your lordships to one of the affidavit before that. Now, your lordships kindly consider the first affidavit filed by the commission, because 6th and 7th, before they comply with, they have to satisfy how this has happened, your lordships, even before going to the 6th and 7th. Now, your lordships kindly come to the first affidavit affirmed by the commission on 27th March 2023. But at page 4 of that affidavit, paragraph 9. But kindly consider, my lord. After completion of the interviews of all eligible candidates, the commission took up the task to recheck various aspects of each aforesaid 14,052 candidates. Well, these are the interview listed candidates, 14,052. The said exercise included a complete re-evaluation. Well, kindly consider, this is a selection process. Complete re-evaluation and scrutiny of all relevant documents, including the scanned copies of the original OMRs of the candidates who participated in TET 2015 by the independent agency. Well, just for a moment, therefore they are making evaluation of the scanned copies, not the original.
Who are you? Who are you actually?
I tell your lordships. There I am appearing for 2 sets of candidates now.
Who are the
First appeal, which is before your lordships now, on which the first order on 21st January was passed by your lordships. Those are, my lord, candidates who questioned the very interview list itself. The very interview list. Then this order was passed. So therefore, we are in respect of those, your lordships, paragraph 6 and 7 of the part of the order. And the other malad application malad, the application is moved by my client. That's malad addition of party can 56. These persons malad were in the interview list, but they have been put out of the merit list. Malad, how they got it that they have been put merit list because of in the paragraph they have said they have been put out of the merit list on the basis of this evaluation of the OMS. So there are two sorts of candidates, two group of candidates I am addressing your lawsuits. Now kindly see how the commission has proceeded with. Apart from grievance mechanism, I will take your lawsuits. However, the OMS seats relating to TATE 2011 were not scrutinized as the TATE 2011 examination was concluded long back, not just 4 years before. And all candidates have been issued mark sheets and certificates. Both of the candidates have been issued mark sheets. 2015, 2011. After evaluation and scrutiny of the OMS seats of TATE 2015, it appeared that there were 3 missing OMS which could not be freshly evaluated. Further, certain irregularities were detected with regard to OMS of 1463 candidates who went out of zone of the consideration, even from the interview list. The irregularities included, kindly consider now your losses. Caste category mismatch of 2 candidates. Kindly see the mismatch of marks in case of 559 candidates of the 1463 OMR seats and defaced OMR seats in case of 902 others along with mismatch for which 1463 candidates have been treated as ineligible. After removal of the said 1463 ineligible candidates, I am now appearing in the by way of addition of party this 1460 out of some of them. The total number of candidates who successfully appear in the interview are fit to be included in the final merit list. Who is 12589. The final merit list of the re-evaluation and scrutiny reveals that only 12589 candidates are now eligible to be included in the merit list and pass waiting list shown below. Now kindly see your lordships, the chart they have shown. Set of candidates successfully appearing in the interview for being included in the merit list, out of which going out of the zone of consideration of the newly re-evaluated marks exceeded TATE marks. Can it be done by the selection committee? TATE marks have been given in 2015. In the process of selection,
You not bring all this before the grievance redressal mechanism.
I tell you losses, this was before the earlier round of litigation, before this honorable court, by which the entire selection process was cancelled. This honorable court came to the finding re-evaluation of TATE cannot be done. Even then they have done it. And this we could not, because this is in the grievance mechanism cell, because this is after the grievance mechanism cell. This came out from their affidavit. After the complaints regarding the grievance in writing made before the authorities.
But weightage has to be given to all the academic scores, including
TATE.
then
Your losses TATE suppose I have got 60% marked according to my mark sheets. Their evaluation says now I am 30.
let them publish that without, they will not implement that. Let them publish that along with your chart, or you will be in a better position to understand your position.
Right, that's
Instead of arguing on affidavit, let them publish it. Let them publish your chart.
I tell you losses, kindly consider this. This has been done only in respect of the candidates who are in the interview list.
Even those persons who are left out of the interview list, they have a separate chart.
No, they have not done even re-evaluation in respect of them.
Point it out after the chart is there with you.
Then your losses, if your losses at all, it's commensurate to your losses.
Because this kind of a lecture-oriented discussion is meaning nothing. If you want to point out to some statistics, they want to publish the interview, publish the waiting list, publish your chart also. Take the hard chart, come back to this court and show us illustratively. This is how the weightage has been done. This is how the interview.
Weightage is one thing, Probably, I am going little deep of it. Can there be any re-evaluation?
They have said from the chart.
They have said they have done. They have said. And they have made 1460 candidates out of the interview. Can they do it? Re-evaluation, my lord. I have been given mark sheets of 2015. They both kindly consider this. May I place the judgment of the earliest judgment your lordships? Kindly look at it. They cannot be. Your lordships will get it. We have filed a reply in the form of affidavit which contains the judgment. Kindly consider this. Little bulky, your lordships will find the affidavit. Page
number 15, page number 43.
It starts at page, quite longest judgment by which the entire process was cancelled, at page 29. Even they say now, on the basis of the scan copies, there were whitening in the OMR. In the affidavit says. It starts at page 29.
Page number 43.
It starts at page, running page. 43.
And the start. The start re-evaluation and
No, ওটা দিয়ে লাভ নেই। Now your losses kindly come to page 45. This is one of an issue. Page 45, the last two lines. Well, it starts with the expression third. The commission cannot now contain that the conduct of TET is a different process and not connected to the present selection process. Rule 12(5) of the 2016 rules give weightage to a TET candidate marks and makes it clear that TET weightage would have a bearing on a candidate being selected for the merit list as detailed further in part A of Schedule 3. Therefore, any alteration of the TET marks would directly impact a candidate successfully proceeding from the interview list to the next stage of the merit list. Further, no notice or intimation was given to the candidates prior to carrying out that reassessment. Well, they said earlier occasion also the reassessment was carried out. The candidates were also not informed of the result of the reassessment. This assumes importance since clause 11 of the information brochure published by the Commission for candidates appearing for the test state level teacher eligibility list 2015 specifically states that no request for rechecking, reassessment, re-evaluation or scrutiny of OMR answer sheets will be entertained and no correspondence in this regard will be entertained. Well, if this is the conditions of the TET examination, can a selection committee re-evaluate the TET OMR?
It is re-evaluation or granting weightage. What is it?
Well, they have re-evaluated.
Where is evidence of that?
That's your losses kindly see.
How much did you get in TET and what was the re-evaluation? Show that.
Marks now they have said only these candidates have re-evaluated and certain candidates have been put out of zone of consideration. That your losses kindly for the time being I am not placing that judgment. Kindly the affidavit your losses looking for page 5 that I was placing of the commission's affidavit. Clean affidavit. Kindly look at this. On the basis of cans copies of the OMR sheet, selection committee exercising this taking exercise. Page 5. Your losses I was placing after 12 lines the irregularities. This expression start the irregularities. The irregularities included caste category mismatch of two candidates. Then your losses mismatch of marks in case of 559 of the 1463 OMR sheets. What they are doing your losses therefore with the mark sheets they are comparing with the scan copy of the OMR sheets of 2015. Whether this is mismatching. I have my own mark sheets given by the commission. And then your losses difference to OMR. So show us 902.
Show us one place where this grievance was brought before the redressal mechanism.
Sir, I could not. This is after that grievance. After the filing of the grievance concluded this has come up. And by the very recently by the affidavit. This was not before.
How have we tried to protect you by our order of directing the commission to do all this? Successful panel of interviews. How have you been protected, if at all, by this order where the commission has said these are the following steps, 7 steps required to be taken?
Exactly, Malak. That's what your lordships have protected us. If your lordships kindly consider this. Malak, the third clause, 6th and 7th. Third, no appointment will be made. My learned friend is pointing out the commission cannot make appointment. That's true. Commission is making recommendation. Board will issue the appointment. That's not the point. The whole purpose of your lordship's order that unless the exercise is done, you cannot proceed.
So where has it been frustrated by this exercise? Show us
exactly. Kindly your lordship 6. At the end of the time period for completing the grievance redressal mechanism, the commission shall produce chart. Here they have frustrated. When the grievance mechanism was open, we have made certain allegations in respect of the preparation of the interview list in terms of the earlier order of this honorable court. They were prevented from making reassessment. Now in the affidavit, after the interview is done and so-called merit list prepared, they are disclosing by the two affidavits that they have re-evaluated the OMR sheets. How could I do it in the, we could not do it before the grievance mechanism, sir. This is their frustrating. The commission shall produce chart in respect of the agreed candidates containing their actual and statutory marks, the weightage granted against each of them under Rule 12 and keeping the space for personality. Test marks blank as well as stating any other issue of the particular relevance to the agreed candidate. I'm going to pause here for a moment. Why your lordships directed them in respect of us to keep the portion blank for personality test so that your lordships can scrutinize the interview. Such the grievance is of such gravity of grievance, your lordships directed them to keep it blank. Then 7th, on the next day, the commission shall place before the combined merit list data base of the candidates actually interviewed in terms of the directions given above, as well as the database reflecting the redressal mechanism of the agreed candidates before this court for further directions. But here again they are frustrating because we could not make this grievance. Kindly visualize, grievance was available to them, those who were not in the interview list. But what they have done in respect of certain interview list candidates, they have re-evaluated of the OMR 6, 1463 and kept them out of zone of the consideration of the merit list.
What is your second complaint? One is against re-evaluation of OMR of your TET marks.
State marks.
That is one, the first complaint. What is the second complaint?
Second, I tell you losses. Kindly consider our first affidavit given, my lord. Just a minute, my lord. This one, no? Just a minute. The first affidavit. I have taken, my lord, after grievance. Oh, no, not this one. Our affidavit. No, it is AR2A of recognition. No, it can open. Now your losses kindly take up one affidavit in reply on behalf of the applicants to their affidavit in opposition. Annex করিস নি না গ্রিভান্সটা আচ্ছা Yeah, just take the losses. 116. Malad, the bulky one which was your losses looking for, Malad, looking at your losses, kindly have a look at page 116. What was our grievances and how they have dealt with? One of the example. Reply. Your losses, kindly page 116.
Question is one. They could not re-evaluate the TET.
Exactly, Malad.
That is one grievance. Second grievance.
Second grievance, I tell you losses. We have raised, Malad, 3-4, Malad, complaint before the grievance redressal cell. The first complaint your losses was that increase of academic marks of certain candidates. We have given example. Malad, I can take your losses how they have dealt with. They have not dealt with at all. We have said your losses, then certain candidates in the application form did not disclose their training qualification. But subsequently, that has been inserted.
You should have actually, the shoes should have been reversed. You should have taken the examination. They should have appeared for the examination. That is how you have understood so much about the process of taking examinations. Why should you be examinees anymore? You should be bored.
But I tell you losses, system has become so corrupt. One cannot survive in the system. They are doing it. Can you losses visualize the selection committee re-evaluate the TET marks or TET OMRC?
Yes, that is the question we intend to pose to the board. What is the second? Your academic marks.
Academic. Your losses kindly consider. Your losses page 116. Page 116 of the affidavit which was little bulky. Now kindly consider what was the complaint and how they have dealt with it. Kindly consider page 116. Just the last paragraph. Upon publication of the interview list dated 21st June 2021 for pure science, medium Bengali, general male and female category, read with this of the commission. Date roll number such and such. General male for MP 10 marks having above 60 marks, for HS 8 marks for having above 50 marks but below 60 marks, for graduation 16 marks for having 50 marks, and BA 10 marks for having above 60% marks, and for TET weightage 27.72 marks for having 69.3% marks. Thus, he is entitled to 71.72 marks in total. Now, kindly see. On the contrary, it transpires from the details of Netai Mondol as published by the Commission on 8 July 2021 that his allotment of statutory marks for HS examination has been illegally enhanced from 8 to 10 marks. For graduation from 16 marks to 20 marks. In utter violation of Rule 12.4 read with Part A of the Schedule 2 of the Recruitment Rules 2016. The 6 marks in his total marks have been wrongly increased and enhanced, and thereby total marks has also been increased and enhanced from 71.72 marks to 77.73 marks. Photocopy of the online application of Netai Mondol as downloaded from the website of the Commission is enclosed here to and marked as such. How they have dealt with, I will place it to your losses. Let me place.
Let us go to Rule 12.4 first.
Rule 12.4 first. Just ball, please, ball. Your losses kindly come to page 101.
Yes.
12.4. Kindly consider. The Central Commission shall prepare and publish in their website an interview list. But this should be an. It should not be an. an interview list with all details of the candidates to be called for personality test, category wise, on the basis of merit as mentioned in part 1 of schedule 2 in the ratio of 1:1.4. Matlab part 1 of the schedule 2 your losses will be getting at page part 1 of schedule 2 at page 107. How the marks to be allocated. Kindly consider part A schedule 2 Madhyamik or its equivalent, full marks 10, 60% above 10, below 50% and above 8, and below 50% 6. H is class 2 stage or pre-university or intermediate university entrance or its equivalent. 10, 60% and above 10, 50% above 8 and 50% above 6. Then grab bachelor's degree as mentioned under clause 2D of the rule 2 of the said rules. 20 full marks, 60% and above 20, 50% and above 18, below 50% 16. So therefore, my lord, we have placed before the commission in respect of Nitai Mondal that these application according to
Now let us compare Nitai Mondal with this once more.
which one, my lord, dear losses? Our complaint,
Yes.
dear losses.
The part which goes to Nitai Mondal.
Yes.
Let us compare.
Now your losses will find page 116. Well, we have first said the last paragraph after the expression general mail.
Yes.
Well, we have just quoted what is in the rules. Marks for having 60% and above, 10 marks. For H8, 50% marks but below 60 he got. For graduation, 60%, 16 marks for having below 50% marks. For B.Ed, 10 for having above 60 marks. For TET weightage, 27.2 marks for 69.3 marks. Thus, Nitai Mondal was entitled to obtain 71.72. This we have calculated on the basis of application disclosed in the website.
And
But
what
what they have done, your losses kindly see. It transpires from the details of Nitai Mondal as published by the Commission 8 July. His allotment of statutory marks for AHS examination has been illegally enhanced from 8 to 10 marks. He was entitled to 8 marks, above 50, below 60. But this has been given 10, as if 60.
Yes.
Then your lordships for graduation from 16 marks to 20 marks in utter violation of Rule 12.4, read with Part A, Schedule 2 of the recruitment rules. He is entitled to 16 because he is below 50, but he has been given 20.
How have they dealt with this in the...
And I am just your losses, page 130. According to them, they have given very good hearing to us. Page 130. 30. Hey, get up. ওদের অর্ডারটা কই? হ্যাঁ, রিজেন্ট অর্ডার 159 ভুল পেজ বলবি না 159 মালক অর্ডার
Only in respect to Nitai Mondal.
মালক আইবি গ্লাসেস
With respect to Nitai Mondal, how much?
dealt with that all. Kind of a look. I do not find at least.
Yes, what is the reason order sheet?
This is what page 1. Read in order sheet, I tell you lost it. Upon perusal of all marks in 10 score, total 10 score, and therefore not qualified. They are saying I am not qualified. If the others, those who have been qualified illegally, automatically I will be disqualified. Then they do not deal with Nitai Mondal.
Place the reason order.
I tell you lordships. Had the petitioner Rajiv Brahma, had the representative of the School Service Commission peruse the documents at random the records of this commission, it appears the petitioner has not uploaded a scanned copy of original mark sheet of MP during online verification process, so he has been declared as rejected. The petitioner submitted that all the relevant documents have been properly uploaded as per order of the commission in time. He also submitted that lesser qualified and untrained candidates have been included in the merit list. He submitted details of the following alleged candidates along with relevant documents. We gave 2 candidates names who are untrained because untrained are not qualified. This says this. Kindly see. Upon perusal of all, his mark sheet of MP is accepted with 10 score and his total score is updated in West Bengal Commission portal. After updating, his total mark stands below the relevant cut-off marks. Therefore, he is declared not qualified. Then, regarding untrained candidates in the merit list, the present case records along with all relevant documents are hereby forwarded to the Secretary of the Commission to ascertain the truth of the grievance and for comments to the concerned. Now, kindly see the Secretary's comments at the bottom in handwriting. The petitioner's complaint against 2 candidates has been found no basis after verification. They did not deal with it. First, Nitai Mondal, they did not disclose how the untrained candidate has been included in the list. I have other grievances. So this is one of the example how they have their grievance mechanism has been acted upon, our grievances. And there are other grievances, your lordship, the vacancy.
Show has come to page 161. What is this weightage?
161. Matlab, this is your losses, kindly consider. Matlab, this is your losses in respect of the petitioner Rajiv Brahmo. According to them, this was not uploaded, my Madhyamik mark sheet, but according to me, I uploaded because of your computer glitches, this was not recorded. Ultimately, they accepted, and this is. Matlab, kindly see the cut-off marks, 75 for Sachans and 73. And therefore, I am rejected. They do not deal with my grievances. That how could you enhance the marks of the candidates? There are other examples, my lord. I am showing one. They do not deal with that.
Then that is the third category of.
Third category. Now your losses.
What is the other? What are your other grievances?
I tell you losses. Other grievances.
We have completed one. We have completed two grievances.
Now your losses. Kindly come to the thin affidavit that was I placing before losses affirmed by Rajiv Brahmo. Affidavit in reply only. Paragraph 70.
Yes.
May I just read out your losses? The petitioner appellants also specifically state that the interview list consisting of 1543 candidates was not prepared in accordance with the mandate, letter and spirit in terms of Rule 12.4 of the Rules of 2016.
Which page?
Page Malak 6, paragraph 7, small d. The petitioner appellants also specifically state that the interview list consisting of 15436 candidates was not prepared in accordance with the mandate, letter and spirit in terms of Rules 12.4 of the Rules of 2016, inasmuch as, while preparing the interview list category-wise, the Commission included the candidates belonging to other categories, namely SC, ST, OBCA and OBCB, etc., in the list of candidates of general category. And as a result, not only lesser number of general candidates were included in the interview list, but also birth in respect of reserved categories were left blank or kept vacant. Had the interview list for general candidates been prepared with only general category candidates, not only more number of candidates would have come within the zone of consideration of 1:1.4, but also none of the birth in respect of the reserved category would have been left vacant. This act on the part of the Commission has not only synchronized competition amongst eligible available candidates in the open market in accordance with rules, but also constituted violation of Rule 12.4. Malab, the Rule 12.4, if you losses, kindly one consider. This is a very serious question now, Malab. Kindly consider page 101. May I just read out the Rule 12, Sub-Rule 4. This is in regard to preparation of the interview list. The Central Commission shall prepare and publish in their website an interview list with all details of the candidates to be called for personal list, category-wise, on the basis of merit. As category-wise on the basis of merit, as mentioned in Part 4 in Schedule. Therefore, while preparing the merit list, category-wise, means that this is general, this is scheduled caste, this is scheduled tribe, this is OBCA, this is OBCB, this is physically handicapped. Can they include on the basis of academic score and TET marks a scheduled caste candidate who have secured higher marks than the general candidate in the category of the interview list of general candidate? The judgment of the Supreme Court says that merit in the respect of general candidates panel to be on the, if any candidate gets ultimately higher marks, he can be included in the panel. But can it be, my lord, adopted or applied in the at the time of preparation of the interview list?
No, we could not follow.
I tell your lordships. What they have done, your lordships, when they are preparing the category-wise interview list, they have included the scheduled caste, scheduled tribe, OBCA and OBC category candidates in the category of general candidates on the basis of purported marks they have secured higher than the general candidates. Yeah. According to us, this is unconstitutional and violative of Rule 12.4.
Why?
I tell you, lordships. Interview list to be prepared category-wise.
That is not the legal position as we understand.
This is the legal position at the time of preparation of merit list, not the interview list. Kindly consider.
Prior to interview, the person under the category of OBC or scheduled caste who has achieved higher marks has been included in the general category.
Exactly. Before the interview. In the interview list means those who are going to be interviewed. In that list, in the general category, they have included the candidates of SC, ST, OBC on the basis of they have secured higher marks in the academic qualification. This demolishes the
Therefore, if you have, the inclusion can be only after the final performance.
Exactly. After adding the academic score and the personality test score, not at the stage of the interview.
Correct, correct.
This is our Malat case. This is third case. Now, your lordships, kindly consider, Malat, we have narrated how this is the consequences of this in paragraph 7E and paragraph 7F. What are the consequences of it? The consequences is, your lordships, lesser number of general candidates getting called for interview, and the scheduled caste candidate, there is a quota, those quotas remain vacant. This is the consequences. So this is a and inroad on the recruitment of the general category candidates. It can be at the final selection after adding both the marks, academic and score. If someone gets higher than the general candidate, he show maybe scheduled caste, scheduled tribe, OBC, he can certainly be treated as not treated to be considered in the category of general. But for that reason, the total vacancy of the seat of scheduled caste will not diminish. That's the law, as I have understood. That's the settled law. But at the interview stage, then they are getting benefit which was.
Got the point.
Then your losses.
The next point.
Next year loss. Now paragraph 7G. At page 8. Let me read out page 8. Apart from the above reserve category candidates who had availed of the benefits of relaxation like concession of age, marks, etc., have been treated as unreserved category candidates of merit for inclusion against the vacancies on the ratio of 1:1/4 while preparing the interview list for unreserved category candidates. It is now well settled principle that a reserved category candidate who has availed of the benefits of relaxation such as concession of age, marks and academic qualification, etc., cannot migrate or claim to be included in the general or unreserved category candidates as they are not on the same standard of merit. For the sake of benefit, only one example is cited here. Nasiruddin Biswas, serial number 992, pure science Bengali medium, interview list meant for male, female and general. He has got the benefit of relaxation. I take your loss to this point because the last judgment of Nirav Kumar of the Supreme Court says that following the earlier judgment also, except Jitendra Kumar comes from Uttar Pradesh Allahabad High Court, that if a scheduled caste category candidate availed of the benefit of relaxation like age, marks or any other concession, he has to be treated right from the beginning as scheduled caste category against the scheduled caste category vacancies. Just because he got higher marks, he cannot be considered against unreserved vacancy. That's the judgment that they have again violated. The act itself, OBC A and B, OBC A in our state includes almost 97 to 98% candidates of a particular community. Now, those particular community getting benefit of age relaxation because of OBC A, and your lordships, the other benefits in marks. Now, having availed of that benefit, he has to stick to his own category. That's the OBC, the Reservation Act says. On the basis, the language, your lordships, on the same standard of merit. This expression has been dealt with by the Honorable Supreme Court and said it includes age and marks. So this is not only unconstitutional, this inclusion, but also
In the merit list also, after obtaining,
exactly, yeah, right form.
after obtaining higher marks than the
Even then, he has to stick to his own category because he can't get the two benefits. That's the judgment of the Supreme Court. And the Act says, on the same standard of merit. Even if he gets avails of the benefit of age relaxation, even then he cannot. Then your losses kindly, the next, this is the fourth, 7H. The petitioner appellants humbly submit that the commission should be directed to open the link in respect of submission of original application.
Mr. Chandra, you were intending to show us the rules.
I beg your lordship.
You were intending to show us the rules.
Oh, that's OBC OBC Reservation Act 2012. Well, just a minute, I'm giving a judgment. Give me just this time. Let me proceed. I will be placing that. Just give me. I will place on this. The Act and the judgment of the Supreme Court also. The petitioner appellants humbly submit that the commission should be directed to open the link in respect of submission of the original applications by the respective candidates, inasmuch as, in the absence of such link which was available earlier, the petitioner appellants are not in a position to get the details of the candidates, of the candidate included in the interview list, and the candidates to be included in the panel to be prepared by the commission. The submission of the petitioner is coherent with the rule of transparency and fairness. But I tell you, lordships, in order to make grievances, we want the application of each other. If I have a grievance against my learned friend's client, whether he was properly selected or not, if my learned friend's client's application I do not get, I cannot. I have to know that they have scored. Equally, my learned friend is entitled to get my application and details. Otherwise, my lord, this is in consonance and in coherence with the my lord, principle of fair play and transparency. Because my lord, some of the applicants we got
That was not published.
not published. That was my lord, that portal was open initially before the first judgment of our High Court. We gathered some information. Thereafter, they closed it because they are getting the information. I can get it. How could I make a complaint unless I get it? Like Nitai Mondal, his application we luckily got. We kept it. That's why we can point out to your lawsuit. This is the illegality they have committed. Unless all the applications we get, we cannot. So, these I am paying before any further exercise by your lordships. These portals should be open to all of us. I don't find any logic.
Which portals?
The application portals. Kindly look at paragraph 7H. The petitioner appellant humbly submit that the commission should be directed to open the link in respect of submission of the original application by the respective candidates. In as much as in absence of such link which was available earlier, the petitioner appellants are not in a position to get the details of the candidates included in the interview list. I tell you, lordships, suppose I am not in the interview list for one set of candidates I am appearing. They have said they have kept interview list 14,000. I require those 14,000 applications in the website. They need not give me the hard copy.
Online application.
This was not done, my lord. Your lordships can certainly.
On the website, what will you see that weightage given to each of
My
them?
lord, I tell you, lordships, on the way I first see his disclosure of qualifications and percentage of mark. If I get it, I can tally with the interview list.
With the
Interview list, how much marks have been assigned by the allocated by the commission. We get it in respect of Nitai Mondal, we have pointed out. There are others, but not much because I do not have the access to the system. This requires application ID of that particular candidate. Application ID will be getting, my lord, for the knowing the marks allocated by the commission to the interview listed candidates. We require the application ID of that particular applicant. We can get it only from his own
So
application.
now if we ask the board that let them publish their result and also open the application portal for you, then you can come back to the court.
My lord, I tell you, lordships, we are at the interview stage. Your lordships probably have gone far. If the interview list goes, what would be it is a futile exercise.
No, it is just for the purpose of comparison. Your comparison, you come back.
My lord, your lordships direct them to publish the all.
We are imagining a situation where whether by fits or starts or whatever it is, the process can go forward somewhat.
My lord, I tell you, lordships, so far my lord, I should express, my lord,
What we envisage for you, you should be in a position to compare everything at yours before any final step is taken. How can that be ensured?
my lord, I tell you, lordships, kindly consider this. We came up before this court questioning the interview list, very interview list.
Yes.
Now, my lord, I request your lordships, pursuant to your lordships order, they have proceeded. So, okay, they have proceeded up to the merit list on the basis of that interview list. My only submission, if the interview list goes, the further exercise will be futile. So there is no need to exercise further. My lord, all that I am saying, your lordships, kindly those 14,000 applications to be published in the website and the interview list marks have been given to them. So that we can compare and come up. We have given, my lord, thereafter your lordships have the evaluation of OMRC, my lord, this exercise of power, the reservation policy, all these have to be considered.
On the basis of allotment of marks.
Exactly. And the other very vital point, your lordships, I take your lordships. No, এখানে বলেছি তো। আচ্ছা, kindly consider, my lord, page 119, the continuation of my grievance application. কত নম্বর প্যারাগ্রাফটা বল? 119 নয় তো তাহলে ওটা। Page 119. My lord, this has been in this respect, my lord, already, my lord, our High Court has passed a notice, but they are not complying with it. Kindly consider this, my lord. Page 119, this is one of our grievances that has not been addressed. My lord, last part, 4 paragraphs. In terms of Rule 12.4, has you also got that one? In terms of Rule 12.4 of the Recruitment Rules 2016, the interview list is to be prepared by the Commission on the ratio of 1:14. Here, your lordships. This presupposes number of vacancies, otherwise ratio cannot be ascertained of candidates to be included in the interview list. Well, let me proceed a little further. Rule 8.3b, read with Rule 9.3 of the Recruitment Rules 2016, stipulates that final vacancy list has to be published 15 days before the date of publication of the interview list by including all the vacancies up to 15 days before the date of publication of the interview list on the basis of the report in sub-rule 2 of Rule 2.8 thereof. So therefore, my lord, all these rules conceives that the vacancy list, final vacancy list to be published before the interview list. What was the reason, my lord, of the rule? Rule because suppose your loss is 10,000 vacancies. This is as if that there are throughout the state 10,000 vacancies. Therefore, Malad, the candidates to be called for 1:1.8 on that basis. What they are doing, Malad, the entire exercise was cancelled. Earlier also they did not publish. So earlier interview list also cancelled by this honorable court. This is a face interview list published on date. Date the first interview, Malad, this interview list published on 21st June 2021. So, my lord, they have to publish the final vacancy list on the date of 7th June 2021. That they have not published. This is another violation of the rule and the order of this honorable court in the earlier process of litigation. Therefore, how could they arrive at a figure? My lord, advertisement disclose the tentative vacancies, but the rule doesn't, my lord, permit on that basis to be the selection process to be followed. Rule permits that you have to disclose the final vacancy list throughout the state just before publication of the 15 days. That means 7th June of 2021. They have not published. Then how could they prepare the interview list? Because in the meantime, my lord, on the basis of their affidavit, 5,000 vacancies more have fallen vacant. 10,000, more than 10,000. Initially they came, my lord, and said 5,000. So this has to be included. If this is to be included, my lord, they have called for 14,000. This should be 24,000. How could the interview list to be sustained then? This was the this has to be followed. That was the judgment of the earlier order of the Honorable Court. I can take your losses to that part of the judgment.
So please come back to your prayer. You want publication of the interview list with publication of
Those interview listed candidates' original application in the first application, so that we can compare with it. And
with all the original application.
in the website, that would do, man. We don't want hard copies.
Yes, website.
Because we can, still, if you permit me, I can point out.
No more. Yes, Dr. Patro, my learned brother finds the prayer completely understandable. I also do that. We both feel that, yes, why should you not open up your interview list? The application for our website.
With all details and
Original application which my learned friend is talking about, the online application, this was also argued on the last occasion. I had submitted one thing, that is the original online applications, the marks mentioned there, the percentage of marks obtained by the candidates. It is all calculated by the candidates themselves. That is why there is the process of verification. We verify. Sometimes they do miscalculations. On verification, sometimes their marks go up, their marks go down. So the manner in which they are relying on those online applications as to be the final marks of the candidates, and any change is an illegality on our part, that is a very wrong approach coming from their end. Even though they
how do you make the case of that Nitai Mondal? How do you handle that man? That which has been
Nitai Mondal's case, I will have to verify whether at all he is in the merit list, whether at all he is of the same category as the candidates, because the grievance hearing was for individual grievances, not for wholesale. Your lordships have seen the amount of grievance they have put into one application, where I am hearing 15,000 applications.
True.
They are to only correlate to the grievance which is directly affecting the candidate. So I might belong to a particular subject, I might belong to a particular medium of instruction, I might belong to a particular caste category. That is why we have almost 350 different panels, 350 different wait lists. They are to correlate directly. Only then can a grievance be redressed. It cannot be like a wholesale. Everything under the sun, each candidate will bring up. Out of 150,000 candidates, one Nitai Mondal, I can come back. I can come back with the specific reply.
Not only Nitai Mondal, there are other Nitais also.
Yes, there will be.
Come back with an entire response from pages 116.
There are several Nitais.
Come back with a complete response to pages 116 to 122.
Yes.
Please come back with a precise response to 116 to 120.
116 to 120. Yes, the grievances. Well, may I say only one thing, Milord? Before your lordships, Milord, there are very few petitioners. Milord, I have not checked up the numbers, maybe 100 or 100 and odd. Milord, we are dealing with, Milord, several thousand posts. Milord, the process of grievance redressal, the process of correction of errors have been undertaken. Milord, we have tried to do it as much as possible, free from error. Milord, there may be one or two errors here and there may be. But Milord, for that, Milord, so many posts, Milord, are being held up. Please consider this, Milord. Milord, under the, Milord, direction of the court, Milord, we have given them the hearing. And Milord, based on that, Milord, now, Milord, we have scrutinized the candidates, done whatever is required to be done, and Milord, we want to publish this. Now, Milord, kindly permit us to publish this. Thereafter, Milord, whatever grievances they have, Milord, that can be taken care of by the court.
Publish what?
The panel that, Milord, we have prepared, Milord, after, Milord, undertaking the
merit list.
Yes.
That will be creating another set of rights. Those people will rush to court and say, now give us appointment.
Yes.
We cannot deal with so many people at the same time.
Yes. But please,
As it is, we are handling whatever mess has been handed over to us to sort out. It was really not our job to sort out this kind of a mess. But we are handling it. This mess was your, apparently was supposed to be handled at your end. You framed the rules. You understood the rules. You should have done everything stepwise.
true, my lord. My lord, our contention is, my lord, one or two grievances here and there, my lord. Please consider, my lord, whether this should stall, my lord, so many thousand posts or candidates. And the ultimate sufferer are the students.
You should have thought of it.
Yes, my lord, we have.
Board should have thought of it.
Yes, definitely. Definitely, my lord, we should have thought of it. Now, my lord, we have undertaken this, my lord, process. Please allow us to, my lord, publish the merit list.
So what happens to page 116 to 122 after you publish the merit list?
Yes, now, for example, my lord, please take my page 116. For example.